Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. I have recorded a video on the mid-year changes that the Georgia Association of Realtors, or GAR, has made to their contract package. I recorded the video and it turned into, the video was a little bit too long for one video. So I have divided it into two separate videos, and I invite you to please watch both videos. The first video on the 2022 changes that the Georgia Association of Realtors made to the contract package includes information as to where you can find those changes in the contract forms, where you can find a list of what those are, changes to the seller brokerage agreement, changes to the mutual termination of a buyer or seller brokerage agreement, the mid-year changes that GAR made to the purchase and sale agreement, as well as the instructions to the closing attorney regarding agent commission. Part two of the video, or the second video, of the 2022 changes that GAR, Georgia Association of Realtors, made in May of 2022. They actually released those changes May 1st. Includes changes that they made to the FHA and VA loan contingency exhibits, changes they made to the documents regarding a closing attorney as the holder of earnest money, the F510, which is the exhibit that goes with the contract, and the F511, which is the agreement that the closing attorney actually signs. Changes, mid-year changes to the residential lease, two brand new special stipulations, as well as changes, a lot of changes, not a lot, but substantial changes to the buyer brokerage agreement. And if you stay tuned to the very end of part two of the changes, I have a bonus special stipulation for you. So thank you guys so much for watching. I do appreciate your time. And please make sure to watch both videos, part one and part two of the 2022 changes, mid-year changes to the Georgia Association of Realtors contract package. Thank you so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education. Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with the Georgia Association of Realtors mid-year revisions to their contract package. So the GAR, Georgia Association of Realtors, they put out a set of contract forms every January of every year, and then mid-year they do revisions to those contract packages. Now, a lot of times those revisions are simply grammatical corrections or syntax corrections with numbering or things like that. But every now and then they do put in a couple of changes or revisions that do have a wide-ranging impact on the content of the form that they have changed, and to you as a real estate agent in Georgia with regard to your real estate practice. So I want to discuss those today in this video. So stay tuned for all of the revisions. The good news is there are not a lot. And the better news is there are some revisions, especially having to do with the buyer brokerage agreement and a special stipulation I think you guys are going to like. So watch till the end. I'll give you the new special stipulations at the end, and I'll talk about the buyer brokerage agreement at the end just to keep y'all watching. So again, these are available to you wherever you access your GAR or Georgia Association of Realtors contract forms, whether that be through your MLS system or through your broker or through a third-party app that either you have access to or your broker has access to. So for example, in FMLS, they are available through Remind Docs Plus. Through Georgia MLS, they are available through Transaction Desk. And again, there are some other third-party programs out there that your broker may or may not be a party of, or you might have access to, that also have the the GAR contract package. So there is an index of the changes that you have access to, as well as all the other forms, but I am going to discuss those here, and I am going to link here below the video the contract forms with the changes all underlined and my notes on them. So let's dive in, shall we? So let me first talk about the seller brokerage agreement. And again, not a lot of changes, but some changes that I think are relatively substantial. So we all know that in this market, these GAR revisions were released in May 1st of 2022, and we are in a spring market, which is considered a fast market or a busy market. And in essence, what we are experiencing right now is there are fewer sellers than there are buyers. So there are many buyers having to make multiple offers, or sellers are receiving multiple offers on properties from a variety of buyers, and there are a lot of things that buyers are having to do to make their offer more enticing to a seller. In addition, there are a variety of commission issues that are going on. Please watch the video I did on the 2022 GAR contract changes. I addressed a lot of the issues having to do with commission, especially with respect to buyers, in relation to an ongoing lawsuit. And my understanding as of May of 2022 is that lawsuit is still ongoing, so there is no case law established regarding commissions, especially buyer side commissions. But nevertheless, GAR is being proactive, and there is some verbiage that they changed in the January release and in this mid-year revision. One of the things, well, let me just go over what GAR has put in the listing agreement. So in the seller brokerage agreement, under the part about commission. So this is GAR form F101. Under the part about commission, there's a fill in the blank where the seller agrees to pay the listing broker or the seller's broker a total commission on the sale, and the seller's broker agrees to pay a cooperating broker working with a buyer part of that commission. And there's some other information in there. But in the corresponding additional information paragraph under B4B, under sharing a broker's commission with a cooperating broker, it does change. They did change it where it says if it is specified in that section A that a listing broker or a seller's broker is sharing a commission with a cooperating broker, and it goes on about how that is split up, and that the split is based on what the seller has agreed to in this listing agreement. But what they added for the mid-year revision at the end of that section, it states, if this agreement specifies that no commission, a $0 commission, is being paid by the seller's broker to the cooperating broker, then no such commission obligation shall exist. So, in other words, a seller's broker, if it is specified in the listing agreement that there is no co-op, no money co-oping, then there is no obligation to do that. So you buyer's agents, when you are working with a buyer buying a property and the seller is not paying commission, there's no obligation for the listing broker to pay a co-op commission if it is specified in the listing agreement. And I've done other videos on that. Y'all need to check that out in the buyer's brokerage agreement, which I'm going to get to at the end of this video. Additionally, in the seller's brokerage agreement, there was a little bit of a verbiage change where under the section about limit of broker's liability, there's just a little bit of a wording change. It used to say that there was, and if no commission was paid, then broker's liability was an amount not to exceed $100, and they've changed that to just a flat $100, and that's the majority of the changes for the seller's brokerage agreement. Now, under the mutual termination agreement, This was just a syntax thing. So this is the mutual termination agreement, which is GAR form F152. This is the mutual termination of a brokerage agreement. In other words, a client of the broker, either a buyer client or a seller, if that public client and the broker agree to terminate the brokerage agreement mutually, this is the form that they would fill out. In the brokerage agreements, in the listing agreement and in the buyer's brokerage agreement, it stated in that agreement that if the client relationship or that brokerage agreement was mutually terminated, that there was no protection period. Protection period turned to 0. In the corresponding form, which is the actual termination agreement that the parties sign, the public seller, public buyer, and the broker sign, they still had reference to a protection period. So they just made that correction to correct the fact that there is no, well, let me just read it to you. It is under that section under paragraph 3, and it states, upon the mutual termination of the agreement, the parties shall have no further rights or responsibilities to one another other than the following, which the parties agree shall expressly survive the termination of the agreement. And then there's options under there regarding costs and fees, but there used to be verbiage about a protection period, and they have removed that. There's no commission protection with a mutual termination. And again, that is just to correspond with the verbiage in the actual listing agreement in and of itself. Now, in the purchase and sale agreement, they've added some issues that are some verbiage that again has to do with commission. I guess you can see the theme of the mid-year revisions to the contracts. But in the actual purchase and sale agreement, which is GAR form F201, it does say that if a seller is making a contribution to a buyer's closing costs, and let's say the actual closing costs, prepaid escrows, are less than on the contract what the seller is contributing to the buyer, there is added verbiage that they added in May of this year that says that the seller, the buyer may use the seller's closing cost contribution, including without limitation any commission obligations of the buyer. So again, with this whole theme about commission and what's going on, if a seller or a listing broker is not compensating a buyer's broker commission at closing, and the buyer has to compensate their own broker commission at the closing of a transaction, if the buyer is entitled, per the purchase and sale agreement, to use part of the seller's closing cost contribution to the buyer to pay their brokers, the buyer's broker's commission. So that's what that verbiage is that was added this year. And in addition to that, in the actual purchase and sale agreement, they have added some verbiage to the hold harmless statement. And basically what this says, this is under B7D, under the hold harmless statement. It basically says, this part hasn't been changed. It says that all parties covenant and agree to indemnify and hold the harmless. This is if there is, okay, let me back all the way. If there is an earnest money dispute. In other words, if a buyer and seller have terminated a purchase and sale agreement, they don't agree in writing as to the disbursement of the earnest money, and the broker as the holder is doing the 10-day letter, which if the closing attorney is the holder, they can also do a 10-day letter as long as the financing wasn't cash. If it's an all-cash transaction, closing attorney is the holder, they can't do the 10-day letter, they can't do the contract interpretation, it has to go to court as an interpleader action. But if there is a 10-day letter under the hold harmless section where the buyer and seller agree to hold the holder harmless based on the decision that they make their interpretation of the contract to disperse the earnest money, they've added the verbiage that it says they agree to additionally hold hold the holder harmless, easy for me to say, if the performance for the performance of the holder of its duties, including claims caused in whole or in part by the negligence of the holder. So that's a protection for the holder of the earnest money. Now, in the purchase and sale agreement, there is a lot more information in there added about lead-based paint disclosures to buyers. You guys, a lead-based paint issue is an EPA issue in addition to a contractual issue. So you absolutely need to make sure that you buyer's agents and you listing agents are complying with the disclosures and documentation and rights afforded a buyer purchasing a house or attempting to purchase a house that was built prior to 1978 that may have the lead-based paint, or if there is a lead-based paint hazard in the house, meaning something in the house that may have been painted prior to 1978 that might contain lead-based paint. So there is a lot of new verbiage under this section. It's paragraph B8, again, in the GAR purchase and sale agreement. And it adds in some termination rights for the buyer. So again, you listing agents, you need to make sure that your sellers are completing these disclosures and including these prior to a buyer making an offer on a property. So let me read you what they have added in the GAR purchase and sale agreement regarding lead-based paint and termination rights for a buyer. So here is what it says. If any portion of the property was built prior to 1978, the lead-based paint exhibit, GAR F316, is hereby attached as an exhibit to the agreement. Buyer shall have the right to conduct a lead hazard evaluation within 10 days from the binding agreement date or other mutually agreed upon time period. And the 10 days comes from the EPA. And to terminate this agreement without penalty, meaning they will get their earnest money back upon notice to the seller if lead-based paint and or lead hazards are found, unless these rights are waived by the buyer in the lead-based paint exhibit. Again, F316. If the lead-based paint exhibit gives the buyer the right to terminate this agreement if lead-based paint or lead hazards are found, and such notices of termination is not given within the 10 days from the binding agreement date or whatever other date was mutually agreed upon between the parties, the right to terminate for lead-based paint and or lead hazards shall be waived. So there was confusion before because the EPA states that a buyer has a 10-day right to examine a property for lead-based paint hazards. And there was confusion in the GAR contracts regarding, well, how does that coincide with a buyer's due diligence period or buyer's right to inspect period? Was a buyer obligated, if they wanted this, to have to inspect the house for lead-based paint prior to going binding? When was this time frame? So this verbiage cleared up the time frame issue as well as giving the buyer termination rights regarding the presence of lead-based paint in a property, either on the outside of the property if it was built prior to 1978 or within the property if it was built after 1978.